I call the March 7th, 2022 Administrative Regulation Review Subcommittee to order. Will the Secretary please call the roll?
Senator Rocky Adams, Senator Alvarado,
Here.
Senator Yates, Representative Bridges, here. Representative Frazier Gordon, Representative Marzian, Senator West,
Here.
And Representative Hale.
Here.
We have a quorum.
We do have a quorum today, and with a quorum being present, the subcommittee is duly constituted to do business. The first matter of business on our agenda today is the approval of the minutes of the last meeting. Are there any additions? Minutes? Is there a motion for approval?
So moved.
Is there a second?
Second.
There is a motion and a second. Without objection, it is so ordered. Just a quick reminder to anyone in the room with us, please silence your phones during the meeting. Anybody that will join us on Zoom, please mute your microphone until the time comes for you to speak. If you are joining us on Zoom, please make a note to get in touch with the folks here at the desk, and they will get your question. So having went through the preliminaries, please call the first regulation today.
Secretary of State, 30 KAR 2010 with staff suggested amendment.
This regulation is being amended to include vacancies due to withdrawals in accordance with 21 Regular Session House Bill 574. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A.
Would you join us, please? Would you please identify yourself today for the record at this time? Please.
There. Jennifer Sketchfield, Assistant Secretary of State with Michael Adams.
Thank you, ma'am, for being with us today. There is a staff amendment for this specific reg. Is there a motion for approval, please? There is a motion and a second. Without objection, it is so ordered. Do you have anything you'd like to add?
No, sir.
All right. Are there any questions from any of the members today of the subcommittee on this reg? It appears there are no questions, so thank you today for your time. Please call the next regulation.
Thank you.
Finance and Administration Cabinet, Teachers Retirement System, 102 KAR 1360 Emergency. This does not have additional amendments.
102-1360 Emergency Only establishes disability plan and benefits eligibility for Teachers Retirement System members with less than 5 years of service.
Good afternoon. Would you please identify yourself today for the record? May I ask you please punch the button until the green light is on?
Sorry. Good afternoon. My name is Tamala Biggs, and I'm staff attorney for Teachers Retirement System.
Thank you, Ms. Biggs. We appreciate your time and being with us today. There are no amendments to this regulation. Are there any questions from any of the members? Senator West has a question at this time. Go right ahead, sir.
Thank you, Mr. Chairman. Pretty standard procedure here. I'm right here.
Oh, sorry.
Pretty standard procedure here. What's the reason? Why are we doing an emergency and not an ordinary reg?
Well, at the time this was passed, of course, we did not know. We're still working on the requirements that we'll need for people to be eligible, and we're putting in place a new process for these people to be able to file their application. So in order to have something in place, just in the event something did happen, it's better to be safe than sorry, that we would have people covered under the Fred Capps Act, so there would be something in place to cover them in the event something happened until we got our new administrative regulation in place.
So what I hear is you're working on it, and there should be an ordinary reg at some point.
Yes.
Once you get everything lined out and come
Yes,
up
sir.
with a quality reg, I guess.
Yes.
Okay. Thank you.
That's correct.
Let me just kind of work off that. So at the present time, there is no ordinary reg for this?
No, we put the emergency in place because when the House bill was passed back in March, we started looking at what the bill required and what we would need to do going forward for these new tier employees coming in. So it's going to be very different from what is currently in place. So we want to take our time and do this correctly rather than, take a knee-jerk reaction and then have to come back and fix the process all over again. But we wanted something in place just in case there was an event, these individuals would have some coverage.
Okay, I'm not sure if I'm still following 100% or not. Senator West, I think, wants to follow up.
Yeah, just what regulation, what House bill is this in reaction to?
This is in reaction to, I believe it's House Bill 258 that was passed
258.
in March
Okay.
of 2021. Yes.
Okay. Thank you.
Mm-hmm.
Any other members have any questions? Are the members satisfied with the answers we got? There appears to be no other questions, so thank you for your time. Please call the next regulation.
Thank you.
Boards and Commissions, State Board of Accountancy, 201 KAR 190 with a staff suggested amendment.
201-1190 amends accountancy examination provisions to reorganize sections of the Uniform CPE examination commensurate with changes by the American Institute of Certified Public Accountants and establish website notification of examination results. The staff suggested amendment deletes Section 4, which related to the testing window that is no longer applicable, amends Section 1 to delete the term testing window, amends Section 2 to remove provisions related to the testing window, and amends various sections to comply with KRS Chapter 13A.
Is there someone joining us today from the Board of Accountancy?
Yes, Mr. Chairman. Hello, good afternoon. I'm Joe Donahue. I'm the Executive Director of the State Board of Accountancy.
Thank you, Mr. Donahue. There is a staff amendment on this regulation. Is there a motion for approval? There is a motion and there is a second. Without objection, it is so ordered. Do we have any questions from any of the members for Mr. Donahue today? Thank you, sir, for your time. There appears to be no questions, so please call the next regulation at this time.
Board of Pharmacy, 201 KAR 2106 Emergency and Ordinary. Neither of these have additional amendments.
201 KAR 2106E and O amend to modify the definition of temporary closures and create new requirements for pharmacy permit holders relating to temporary closure, such as written notification to the Board of Pharmacy, patient-facing signage on all pharmacy entrances and drive-through windows, updates on the phone message and website of the pharmacy, an on-call pharmacist who can transfer prescription records, and notification to prescribers of the temporary closure and time and date of anticipated reopening.
Introduce. Oh, yes, sir. Come around. I was looking at the screen, sir. I apologize for that.
That's okay.
Welcome today. Would you please introduce yourself for the record today?
Sure. Good afternoon. My name is Christopher Harlow, the Executive Director of the Kentucky Board of Pharmacy.
Thank you, Mr. Harlow. There are no amendments on this reg. Are there any questions? It appears there are no questions, so thank you for being with us today. Please call the next regulation.
Board of Barbering, 201 KAR 14, 15, 30, 40, 50, 65, 85, 105, 110, 115, 125, 150, and 180. All except 15, 30, and 65 have staff suggested amendment.
201 KR 14015, 30, 50, 65, 85, and 115 all amend to make various terminology changes. Additionally, 14050 deletes the requirement for the application to contain a question asking if the applicant is in arrears or default on a financial assistance program with KIA. 14085 changes the concentration of ethyl alcohol in solution at workstations with from 90 to 70%. 14115 adds language on the deadline for the submission of the application for exam and updates material by reference. 201 KR 14040 amends to require the shop to display the permit card and a current picture of each barber and independent contract owner at the station where the person is working and at each student workstation in a school barbering. 201 KR 14105 amends to clarify the required fee to be submitted along with the enrollment application for a barber school. 201 KR 14110 amends to include whiteboards and school equipment, stipulate the board shall be notified upon any changes made to the school's physical layout, will require the school to provide a minimum of 1 shampoo bowl for every 10 students, and eliminate the requirement for schools to provide manicure tables with liquid sterilizers on each table. 201 KR 14125 amends to delete confusing language relating to industry licensure, provide continuity of terms, reduce the time to qualify from 600 to 400 hours, and remove the 12-month requirement to test. 201 KR 14150 amends to prohibit monthly attendance records from being amended after the last day of the month. 201 KR 14180 amends to change the instructor of barbering examination fee from $250 to $100 per section for 3 sections, decrease the instructor of barbering late fee from $100 to $50, and establish a $100 instructor student permit card fee. The staff amendments for 201 KR 1440, 50, 85, 105, 110, 115, 125, 150, and 180 all amend to make various changes for clarity and to comply with KRS Chapter 13A. Additionally, 201 KR 14115 amends Section 1 to clarify the application deadline, amends Section 9 to update the instructor's application for examination to change the exam fee to $100 per exam section for consistency with 201 KR 14180, and updates all exam applications for consistency with deadline date revisions.
Is that it? All right. Good afternoon, gentlemen. Please identify yourself today for the record.
I'm Mason McNulty. I'm the administrator for the Kentucky Board of Barbering.
Good afternoon. My name is Christopher Hunt. I'm counsel for the Board of Barbering, and kudos for that reading. Very well done.
Thank both of you today for being here with us. There are a lot of regulations here today
Yes, sir.
for barbering.
Lots of cleanup, I think.
Lots of cleanup. There are staff amendments to some of these regulations. Is there a motion for approval? Is there a second?
Second.
There is a motion and there is a second. Without objection, it is so ordered. Are there any questions for either of the gentlemen after that 3-page reading? Surely somebody has a question on something there. The only question, I don't have a question. The only comment that I would have is most people would disagree when you drop 90% alcohol to 70. And I'm joking. I apologize. That's a bad joke, I guess. But did you get that, Senator West? And also, let me just comment on this. I've been on this committee for several years, and I'm not sure yet if I've seen one where the fee is going down. Most of the times our fees are going up. But so there being no questions, thank you all for being with us today. Appreciate
Thank you,
the
sir.
time. Please call the next regulation at this time.
Board of Examiners of Psychology. 201 KAR 26115, 125, 130, 155, 160, 175, 185, 190, 215, 225, 230, 250, 270, and 310. Various ones of these have staff suggested amendments.
201-26-115 is being amended to delete the provision that the practice of psychology shall be construed within the meaning of the definition contained in KRS 319.010 without regard to whether payment is received for services rendered. 26-125 is being amended to add temporary licensed psychological associate, licensed psychologist, and any credential holder under discipline to the list of individuals who are clinically supervised by a health service provider. 26-130 is being amended to comply with the formatting requirements of KRS Chapter 13A. 26-155 is being amended to update material incorporated by reference. 26-160 is being amended to update the required examinations. 26-175 is being amended to require that an application for continuing education be received at least 30 days before the program of instruction, and that a certificate cannot be sent to an attendee until the program is approved by the board. 26-185 is being amended to update provisions and the material incorporated by reference. 26-190 is being amended to clarify the requirements for internships. 26-215 is being amended to update the application form. 26-225 is being amended to update material incorporated by reference. 26-230 is being amended to require that an applicant create a remediation plan if they fail the national exam and to delete the material incorporated by reference section. 26-250 is being amended to specify that supervision must be clinical. 26-270 is being amended to delete unnecessary language pertaining to exam requirements. 26-310 is being amended to require that documentation of the telehealth appointment takes place within 48 hours. The staff suggested amendments to 206, 26, 115, 125, 130, 155, 160, 190, 230, 270, and 310 amends various sections to correct statutory citations, comply with the drafting and formatting requirements of KRS Chapter 13A, and make technical changes.
Whoever's joining us today, would you please identify yourself at this time?
Yes, sir. There's two of us here. I'm Kevin Winstead. I'm the Commissioner of the Department of Professional Licensing and the contact person for these regulations. And I'm joined by the chair of the board, Dr. Nash. Would you care to introduce yourself?
Dr. Brenda Nash, chair of the Kentucky Board of Examiners of Psychology.
Thank you, Dr. Nash and Mr. Winstead, for being with us today. There are staff amendments. Is there a motion for the approval of the staff amendments? There is a motion and there is a second. Without objection, it is so ordered. Are there any questions for either of our presenters today? Yes, sir. Senator Yates. You're behind the pole there, sir. I see you. Go right ahead, please.
Behind that on it. Mr. Chair, Dr. Nash, thank you for being with us today. I had a quick question on the 201 KAR 2615. It looks like it had been deferred from the February meeting, but it was the licensed psychologist, the application, temporary licensing on there. Seeing what changes had that? I know that from my own exploring and even some litigation that we've had some issues sometimes with temporary license being given for psychologists, and there's supposed to be a certain amount of oversight and done, and we're looking to see how those are held accountable for failure to have that oversight when you deal with patients. What changes are being put? Are you familiar with what changes are being put before us?
And you're on mute, doctor.
Can you give me the number again, please, sir?
Yes, it is 201. It's KAR. It's 26-155. Is that in here?
And is it okay if I jump in here at the start, Dr. Nash?
Of course.
Yes, sir. Please go. Either one of you, please proceed.
Thank you. And I believe this one primarily updates some forms, or a form, the application, to clarify how to report information regarding the practicum, and it, of course, changed the revision date. I believe there was a spot on that form that referred to advanced practicum, and that word advanced was being taken out. There was another statement in that part of the form, and here's where I need to pull up the form to get it right, but it said something about they don't need to provide something, and that statement was being removed. And I'll look that up here in just a moment.
And if I may, the reason I ask is it just has a one page, and I was trying to plug it in together, but it's saying that it's going to, it says page 1 under necessity, function, and conformity, under line 10, it says after applicants for licensure, delete. Just want to see, because my concern is we don't want to do anything that would and I know this may be just a very minor change. I just don't want to do anything that could reduce the oversight and the necessity for the requirement that we are having oversight. If someone has a limited license, it means they haven't completed the basic requirements in order to be able to supervise in these clinics. If we're not having somebody check oversight them, then it means our constituents could be at risk. And I just want to make sure that wasn't going to minimize that. And maybe I'm misreading it.
Yeah, and I have the regulation pulled up, and I'm not seeing the place where you're talking about. There is nothing that the board is recommending that would decrease oversight at all. Like, we're in absolute agreement with you. We want as much oversight as we can get over our master's level clinicians and our temporarily licensed folks. So that absolutely is not the intent of any of our changes.
Doctor, you're going to remember I had at the beginning, have to apologize if I'm misreading something. So apparently they just handed it to me. They're not deleting those words. They put those as, they are deleting the comma. And I'm perfectly fine with that. So I just got to bite right up for nothing. But it did. Perfect. It did give me a little heartburn. It worried me. I thought we were getting rid of that oversight. So thank you.
No worries at all.
Thank you, Senator. Any other questions or comments? Thank both of you today for being with us. Appreciate your time. Please call the next regulation at this time.
Board of Licensure for Massage Therapy, 201 KAR 42010, 20, 30, 35, 40, 50, 61, 70, 80, and 110. All except for 10 have staff suggested amendments.
201 KR 42010 amends to update language relating to goals for massage therapy sessions. 201 KR 42020 amends to comply with House Bill 79 from the 2021 regular session, including to update material incorporated by reference and change various fees for the initial massage therapy license, biennial renewal, late renewal, reinstatement, the inactive license fee, annual renewal fee for inactive license, late inactive renewal, initial certificate of good standing, renewal fee for a certificate of good standing, and a one-time certificate of good standing fee for out-of-state schools. 201 KR 42030 amends to require any request for a name change to be made only after submission of a legal document that authorizes the change. 201 KAR 42035 amends to expand the number of approved licensing exams, modify the applicant criminal history portion, and update a form. 201 KAR 42040 amends to establish requirements for reinstating a license expired for less than 5 years, indicate that a revoked license is not eligible, clarify the process to request a KRS Chapter 13B hearing, reduce continuing education required for renewal of an expired license from 24 to 12 hours, and update forms. 201 KAR 42050 amends to require a complaint be in writing and contain specific details, remove procedures to redact and initiating complaint, and update forms. 201 KAR 42061 establishes a code of ethics. 201 KAR 42070 amends to require an applicant to submit a fingerprint check from the FBI, a passport-sized photo, and proof of work for the 6 months preceding 1 year with their application, establish requirements for reciprocity of spouses and dependents of armed forces members, establish that an applicant with a criminal history may be interviewed by the board, establish an appeal procedure, and incorporate a form. 201 KR 42080 amends to reference a one-time non-refundable fee of $50 for a certificate of good standing and a non-refundable fee of $125 for an initial certificate, reference a renewal application fee of $75, lay out procedures for a program of massage therapy instruction that fails to uphold the provisions of KRS 309-363 and includes a revocation fee of the certificate of good standing of $50. Establish conditions upon which a school has met some of the standards for required documentation. Require the school to generate a 12-month statistical report from an exam company that ends 30 days before the certificate anniversary date. Require a program of massage therapy instruction to notify students in writing of any changes in the status of a certificate. Lay out procedures for renewal of a certificate while on probation. Explain procedures if a school is sold or transferred, and update material incorporated by reference. 201 KAR 42110 amends to lower the number of required hours from 24 to 12 hours every 2 years, require at least 3 hours of ethics, establish requirements for specific and required training for massage therapists to use pulsed electromagnetic field or microcurrent devices, and update forms. The staff amendments for 42020, 30, 35, 40, 50, 61, 70, 80, and 110 all make changes for clarity and to comply with KRS Chapter 13A. Additionally, the staff amendment for 070 amends Section 2 for clarity and to delete references to active duty.
All right, thank you again. Would whomever is joining us today please come to the table and identify yourself at this time?
Yes, sir. Kevin Winstead again, here for these regulations as well. Commissioner of the Department of Professional Licensing and contact person for these regulations.
And Denise Logston, representative of the American Massage Therapy Association, Kentucky chapter.
Thank you, Ms. Logsdon, for being with us today. There are staff amendments. Is there a motion for approval of the staff amendments? There is a motion. There is a second. Without objection, it is so ordered. Are there any questions today from any of the members of the subcommittee? Representative Frazier Gordon, proceed, please.
Thank you all for being with us today. It's helpful when you're here in person. I have a question in regards to the letters of good standing, the fees in regard to that. Are there other agencies that charge for these fees? Charge these fees for similar type letters? I've been involved on a couple of different boards and seen regs come through here, and I've never seen a fee for a letter of good standing.
This is maybe different terminology. It's the certificate of good standing is the board's recognition that the school complies with the curricular requirements and the requirements for the teacher. So there is an application process for which we have not charged in the past, and it is detailed. And occasionally somebody moving into another state will have a request from that state to send such letter to them also. So the fee is covering administrative costs.
Go right ahead, please.
So the fees are both to the schools that want to be approved for their educational tracks and also for the licensees?
No, that fee is simply for the schools, and it again is just because that sometimes there are other transactions that happen after they've paid their fee and been established as a recognized school. But there's not a fee involved in this to the licensee.
Okay, that's what I wanted to clarify, because sometimes licensees, if there's not a compact, have to have licensees in bordering states, and so I didn't want them to have to pay a fee to have a license. Okay, thank you.
Thank you, Representative. Any other questions? Thank you all both for being with us this afternoon. Appreciate your time today. Please call the next regulation at this time.
Thank you.
Board for Medical Imaging and Radiation Therapy, 201 KAR 46020 emergency. This does not have additional amendments.
201 46020 emergency amends licensure fees to add a $25 qualification fee for the registration of the limited X-ray machine operator exam and delete the $165 fee for the exam itself.
Whomever is joining us, would you please identify yourself today for the record at this time?
Good afternoon. Elizabeth Morgan, Executive Director for the Board of Medical Imaging and Radiation Therapy.
Thank you very much, Ms. Morgan. There are no amendments to this regulation. Are there any questions from any of the members of the subcommittee? Appearing to be no questions, thank you again. Please call the next regulation at this time.
Tourism, Arts, and Heritage Cabinet, Department of Fish and Wildlife Resources, 301 KAR 5001, 30, and 100. All three have staff suggested amendments.
301 5001 amends chapter definitions to make technical corrections. 301 5030 amends the process for purchasing licenses and permits to reorganize provisions for clarity and make technical corrections. 301 5100 amends procedures for reciprocal enforcement pursuant to the Interstate Wildlife Violators Compact to make technical corrections. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Good afternoon. Please identify yourself today for the record.
Commissioner Rich Storm.
Commissioner
Deputy
Storm.
Commissioner Brian Clark.
Thank you, Commissioner Storm and Mr. Clark. Glad to have you both with us today. There are staff amendments on these regulations. Is there a motion for approval of the staff amendments? Motion. There is a motion and there is a second. Without objection, it is so ordered. Are there any questions from any of the members of the subcommittee regarding these regulations? Commissioner, again, thank you for your time today. Just on the 301-005-100, the interstate wildlife, could you just give me a quick overview of that reg, exactly what that is doing?
Well, simply, this was a sunset reg, and the only change in that is an address change.
Okay.
Yeah.
Okay, so nothing different from what was already there?
Correct.
Okay. Anybody else? Thank you, Commissioner, and thank you, Mr. Clark, for your time today. Please call the next regulation at this time.
Department of Agriculture, Industrial Hemp, 302 KAR 50 021, 31, 46, 56, and 80. None of these have additional amendments.
302 KR 5021 amends provisions for licensing and compliance with Kentucky's hemp program to clarify that an applicant shall not have had a hemp license revoked within 5 years of application, clarify specific location areas to include greenhouses, indoor growing locations, storage buildings, and lots, allow 15 additional days to complete harvesting, clarify the department shall conduct inspections on a random basis, add to the list of factors that result in temporary suspension a grower found to be growing or in possession of cannabis material with a THC concentration of 3% or greater, establish examples of negligent violations, and establish the department shall perform at least 2 inspections pertaining to a corrective action plan. 302 KR 5031 amends provisions for processing and handling hemp to clarify that an applicant shall not have had a hemp license revoked within 5 years of application, establish a licensed processor or handler shall only purchase or receive harvested hemp material compliant with the hemp program in the grower's area, and add to the list of factors that result in temporary suspension if a processor or handler is found to be in possession of cannabis material with a THC concentration of 3% or greater. 302 KR 5046 establishes reporting and record retention duties, including all license holders shall retain all records relating to hemp for at least 3 years, and the department shall submit various reports to the USDA. 302 KR 50056 amends to establish procedures and requirements for hemp sampling and THC testing, and for the movement or disposal of hemp following the completion of THC testing. Add 2 new definitions, certified seed and hemp transplants. Add a new Section 3 in which standards and procedures are established for performance-based sampling if the department cannot sample and test every lot of hemp. Extend the time a licensed grower has to complete the harvest of the crop from a lot from 15 to 30 days after inspection. Update procedures for collecting samples for post-harvest retest of remediated material, and update material incorporated by reference. 302 KR 5080 amends to update material incorporated by reference. The amended after comments versions for 302 KR 5021, 31, 46, 56, and 80 all amend various sections to comply with KRS Chapter 13A. Additionally, 302 KR 5021 adds provisions for universities and colleges to dispose of non-compliant plants.
Would you identify yourself today, please, for the record?
Glenn Quarles, counsel for the KDA.
Thank you, Mr. Quarles. Glad to have you with us today. There are no amendments on these regulations here. Are there any questions from any of the subcommittee members concerning our hemp regulations today? I think Senator West has a question, sir. Go right ahead, Senator.
Thank you, Mr. Quarles. Thank you, Chairman. Could you briefly describe the THC concentration percentage, where we were, and then where does this, in relation to previously where we were, how does this stack up?
Thanks, Mr. West. There's no change with the THC concentration. The only change that you're really seeing here in the collection of filings are to have our set of regs be certified by the United States Department of Agriculture as a state plan and approved by them. The federal THC concentration levels are set at 0.3 of 1%, and Kentucky law and these regulations both follow that level.
Okay. So I see that's 3% is the, so we're not changing the percentage, we're just adding it to the list of factors.
Yes.
That can result in temporary suspension.
Yeah, and it's not 3%, it's a 0.3 of 1%.
Okay.
Yes, sir.
Well, that's why I was looking at it, because in my summary it says 3.00%. So I just, it's
okay.
That's a big change there. So it's
yes,
actually it actually hasn't changed. Yeah, right. That's a high bar, 3%. But so that hasn't changed anything. That was my only question. Thank you.
Any other questions? We thank you today for your time, sir. Appreciate you being with us today. There being no other questions, please call the next regulation.
Justice and Public Safety Cabinet, Department of Corrections, 501 KAR 6030 and 290, both with staff suggested amendments.
501-6030 amends the policies and procedures of Kentucky State Reformatory and deletes several outdated policies. 6290 establishes the policies and procedures of the Southeast State Correctional Complex. The staff suggested amendments to these regulations amends various sections to comply with the drafting requirements of KRS Chapter 13A and the material incorporated by reference for clarity and consistency.
Would you identify yourself today, whomever is joining us at this time?
Good afternoon. My name is Amy Barker. I'm Assistant General Counsel here for the Department of Corrections.
And I'm Brandon Lynch, Justice Program Administrator for the Department of Corrections.
Anyone else? All right. There are staff amendments. Is there a motion for approval of the staff amendments? Motion. There is a motion. Is there a second? Without objection, it is so ordered. Are there any questions from any of the members of this subcommittee for either Ms. Barker or what was your name again, sir? I apologize.
Brandon Lynch.
Okay. Mr. Lynch, any questions for them? We do have someone today that has signed up to speak against 501 KAR 006290. Would you please come to the table today and identify yourself for the record? Please make sure the green button is on there on your microphone. And go right ahead and introduce yourself, sir.
My name is Kevin Sharkey.
I don't believe you're just push until the green light is on.
All right. My name is Kevin Sharkey. I'm a staff attorney with Kentucky Protection and Advocacy.
And I'm David Frank. I'm a senior attorney with Kentucky Protection and Advocacy.
All right, gentlemen. You have signed up today to speak against this one specific reg. You may proceed.
All right. Thank you, distinguished members of the subcommittee. Thank you for allowing me to come and testify today. I'm Kevin Sharkey again, and I work with Kentucky Protection and Advocacy.
Sir, I don't mean to interrupt you, but could you pull that up close to you? So
sorry.
Okay, there you
All
go,
right.
sir.
And we're Kentucky's federally mandated disability rights agency. One of the things that we do is identify and address abuse, neglect, and rights violations in facilities that provide services for people with disabilities. Jails and prisons are the largest providers of mental health services, and therefore one of our priorities is to ensure that mentally ill people in prison, that their rights are not being violated. We've made it a priority of ours to work to end solitary confinement within Kentucky's jails and prisons. Solitary confinement involves housing individuals in a cell for 22 hours a day with minimal contact with other people. Common features of solitary confinement include the absence of human interaction, limited sensory stimulation, and curtailed mental health services. The harsh conditions of solitary confinement often cause symptoms of mental illness to worsen. Because these conditions nurture rather than abate psychosis, numerous federal courts have found that confining seriously mentally ill inmates to isolated housing units for prolonged periods violates the Eighth Amendment's prescription against cruel and unusual punishment. In fact, a bill was recently filed in Kentucky to severely limit the practice. In January, we sought to restrict the use of solitary confinement for people with serious mental illness by filing comments to 2 chapters of Southeast State Correctional Complex's proposed policies and procedures. The chapters we commented on were 10.1.1 Restrictive Housing Unit and 13.7.1 Suicide Prevention and Intervention Program. We appreciate the DLC considering our comments and making changes to the Restrictive Housing Chapter. With respect to the Suicide Prevention and Intervention Chapter of the policies, we recommended that the DLC amend the chapter to ensure that persons with serious mental illness on suicide watch receive significant out-of-cell time for appropriate structured and unstructured activities, including regular and consistent therapy and counseling. We recommended that they be permitted routine privileges such as congregate meals, telephone calls, showers, recreation, unless the individual is actively engaged in behavior that is dangerous to themselves or others. We stated that if for any reason our recommendations could not be accomplished at Southeast State Correctional Complex, then the policy should be amended to provide for the transfer of seriously mentally ill individuals after 72 hours on suicide watch to a facility that can provide a higher level of mental health care in a less restrictive environment. The reason we commented on these changes is because suicide watch is a harsher form of solitary confinement. On suicide watch, inmates are stripped of their clothing and underwear and dressed in a smock made of tear-resistant material. They are placed in a suicide-resistant cell and offered no items of comfort. They are confined to this bare cell for 24 hours a day and are not permitted the 1 to 2 hours of recreation that are typical of regular restrictive housing. Books and magazines are usually not permitted, and meals arrive without utensils, forcing suicidal people to eat food with their hands. The inmates are kept in these conditions until a mental health professional determines that the individual can be housed safely in a less restrictive environment. Inmates sometimes spend months in these conditions. While it is true that placing people on suicide watch does make it harder for them to harm themselves, it also makes it almost impossible to improve their underlying psychiatric problem. The harsh conditions of suicide watch bear little resemblance to genuine psychiatric treatment. In many cases, they make mental health worse. The United States Supreme Court has held that prisons have a duty to provide adequate mental health care. We question whether adequate mental health care can be provided in a setting and under conditions described by one federal judge as incubators of psychosis. For mentally ill suicidal inmates to receive constitutionally adequate mental health care, the DLC should accept protection and advocacy suggestions and provide mentally ill inmates who are suicidal services in a less restrictive setting. Thank you for the opportunity to speak.
Thank you, sir. Mr. Frank, we did not have you actually listed to speak, but I'm going to go ahead and permit. Would you like to add something to that, sir?
No, not at this time. Thank you, though.
Okay. I just, yes.
I would make a suggestion that we allow the cabinet to respond and then come back and do questions all at the same time. But if any
that will be perfectly fine.
If anybody else have a problem with that, I'm okay with the other way too.
The committee will stand at ease. Just a moment.
It's fine.
Senator Yates, I'm going to go ahead and permit you to ask your question at this time.
Thank you. I think Senator West's recommendation is absolutely fitting, but just so we have a context in it, I think when we kept saying significant mental illness, tell me how that, because I know that varies dramatically. Can you tell me how that is defined and what we consider that category? Significantly mentally ill?
It's
it
serious,
can seem ambiguous, yeah.
Serious mental illness, and it's defined in the DSM-5, but I don't know it off the top of my head.
That's fine. I was just trying to see it.
It includes like bipolar, schizophrenia, severe depression. I know that.
And that was my question, because if they're on mental illness, if they're on suicide watch, wouldn't they be by definition usually within depression? And I didn't know if that would be considered, so everyone who had suicidal thoughts would fall underneath that category. Is that correct?
Well, I'm only speaking of those who have been previously diagnosed with a serious mental illness.
Yes, sir, Senator Yates, I'm sorry. I think we may have another question or two, but I am going to go back to the cabinet and allow them to respond, if they would like to the testimony that was just given. You may proceed, please.
Thank you. We did make changes in response to the comments. The DOC it takes mental health very seriously. There is a step-down procedure for suicide watch. The inmates who are on a suicide watch are regularly seen by mental health professionals, and the goal of the department is to move them down the watch process and get them back to normal housing and normal structure as quickly as possible. The review at Southeast showed, and the inmates' seriousness mental health is done by a score, and 4 and 5 are the serious levels, and Southeast State only has up to a 3 at this point. Those two policies generally address short-term issues with an inmate, and if it's a long-term thing, they're often sent to another facility that has a better management system or a looser structure potentially. The department did shift the one policy to a less restrictive framework in response to what P&A commented.
Anything else, ma'am? Senator Yates, I'm going to come back to you. I think you have a question. Is your question for Ms. Barker? Yes, sir. Go ahead, please.
Thank you, Mr. Chair. We've obviously had significant issue in my home in Louisville, at our jails locally, dealing with a lot of mentally ill. I think it's it is the highest facility housing people with mentally ill. And one thing that we've learned is you have to be quick to be able to identify, address it, and then have them in a better facility. What is the standard that you have set once you've identified that someone does have severe mental illness that ranks above the 3? How many hours or days do you have to transfer that person to a facility which could accommodate them?
It depends on the specific inmate, and it depends on the mental health professional and the recommendations made by that mental health professional. In many instances, the inmate may not need to be transferred. Sometimes they are, sometimes they're not. It depends on the specific facts of a specific inmate. And I don't really have specifics. If we need to get really detailed, we're going to have our mental health director available for you, because my knowledge is smaller than his knowledge.
Senator Yates, I think, has a follow-up question. Go ahead, sir.
And fair enough, and I definitely don't want to catch you on the spot. And sometimes I was just checking once they've been identified. I think that when they do an intake or they do an assessment, there's a scale. At some point, there's on a scale that you will be determined that they are not fit for the facility and they need mental health treatment. They should be transferred. And I know that part of that is it's setting a standard of care in which people could be held accountable. I didn't know if you had set, in the event that you reach that scale, you've made a determination that you can't safely house them, how many hours do you have to transfer that? And that may not be a question that you're prepared to answer, and we could do that later. But I did want to put that out there, that's one that I've seen an issue. We've lost a lot of people at my local jail, and it's mostly just negligence and failure to act. And I want to make sure at the state level that we're doing everything we can.
Well, and Brandon and I are happy to look into that and get more information for you. But I don't have that specific information at my fingertips today.
Senator West, is your question for Ms. Barker?
Yes.
Yes, sir. Proceed.
Thank you, Mr. Chairman. In this committee, we often think we know what's going on, but we really don't until we dig down and look into the technical meaning of the regs and the jargon, really, that's behind the regs. So just correct me if I'm wrong, but it's my understanding that we had a reg and that you worked with the public advocates to change it to the current format. And I'm going to ask you to comment on what was there before and what's there now. So it's my understanding that the inmate could be, before the reg said, the inmate could be considered high risk and shall be housed in a restrictive housing unit. The new reg that's before us says an inmate may be assigned to a special management unit if they have severe medical disability or serious mental illness. Could you just describe to us the difference between a restrictive housing unit and a special management unit?
The restrictions are less in a special management unit. I don't have the specifics beyond what we put in our statement of consideration. The hours in a cell is less for special management than for RHU units. I'd have to get those two policies side by side and tell you what the differences are, because I don't have that right at my fingertips either.
Is it safe to say that a special management unit would be, for someone who's mentally ill, would be a much better place to be than a restrictive housing unit?
I think it's a step down from a restricted housing unit.
Okay.
While the policies are not really loose, they are looser than in an RHU. And this policy set it's a new policy set for the newest institution in corrections. The main policies are the corrections policies and procedures in our Chapter 13. And that's where most of our information about mental health and how we respond to it. In this situation, what's in these policies are for differences at this particular institution or to fulfill policies that they have to have for an ACA standard. So this isn't the only thing that impacts an inmate with a mental health issue. The main policies for the Department of Correction are the biggest part of that. And we've worked with P&A many times to make adjustments, and we regularly make changes to our regs when they make comments. We understand what they're after and do our best to provide that. Our facilities just are not mental health hospitals, so we can't get to the point where they would like us to be.
Thank you.
Ms. Barker, where is Southeast State Correctional? Where is that?
Brandon, I'm having a mental blank. It's in Eastern Kentucky, but the city is.
That Southeast State is located in Wheelwright.
Wheelwright, thank you. I apologize.
Any other questions for Ms. Barker? And I'm going to go back to, just for a short response, Mr. Sharkey, do you have anything else you'd like to add, sir? I'll give you the last word.
Just that I believe that it's hard to treat a person or to provide adequate services when they're locked in a cell for 24 hours a day, staring at a gray wall. I think that the person should, whoever's on suicide watch should get more out of cell time for activities in order for his mental health not to get worse.
Have you or someone from your agency witnessed this at this facility?
This is a new facility, so we haven't been to this facility, but I've witnessed where an inmate has been on suicide watch for 2.5 months, and it did not end well for that inmate.
I think Senator West made a great point a moment ago. Sometimes we get these regs, and until we really dig down into them deeper, we don't actually really have a knowledge of what's happening. My suggestion this afternoon would be, and I believe Ms. Barker and her folks would certainly be accommodating to you, to get together, see what can be done to accommodate the individuals there and make it a safer environment for them. I certainly appreciate you bringing this forward to us, sir. I can see the passion hear the passion in your voice about this, and again, I think that the cabinet would be certainly willing to work with you on this for the safety of our inmates there.
Thank you.
And having said that, does anybody else have any other comment? I want to thank all of you for your time and your testimony today. Please call the next regulation at this time.
Department of State Police 502 KAR 15010 with an agency amendment.
502 KAR 15010 amends to add definitions, require law enforcement officers who create a traffic collision report to utilize the electronic submission application, add procedures for a news gathering organization to request a vehicle collision report, update material incorporated by reference, and make minor updates. The agency amendment amends Section 1 to add a definition for traffic collision report, Section 2 to require law enforcement officers to use the eCrash collision reporting system to make traffic collision reports, and allow a party involved in a collision that is not investigated by a law enforcement officer to submit a report using the online civilian collision reporting tool on the department website. Section 8 to update a form and various sections to comply with KRS Chapter 13A.
Please identify yourself for the record today, whoever's with us on this reg.
My name is Amy Barker. I'm Assistant General Counsel here for the Department of Kentucky State Police.
Captain Brad Arterburn with the Kentucky State Police.
Brandon Cobb, Justice Program Administrators, Kentucky State Police.
All right, thank you all again for being with us today. There is an agency amendment to this regulation. Are there any questions or any discussion, on the agency amendment? Senator Yates, on the amendment, sir.
On the amendment.
Go right ahead, please.
Before us, it looks like the amendment before us, it lays out a new section, and part of it just saying that an officer shall make a traffic collision report under the eCrash system. And then if it's not investigated, the officer involved, you should submit it to where they can do the online civilian thing. I'm looking for the requirements. When it does say shall, if we do have an officer that stops in an accident, sees the accident, talks to witnesses, it seemed like they'd be in direct violation if it doesn't say may in the event that they do not perform a traffic collision report. Although I understand that as practice, it's happened several times. They go make a stop and then ask the victims of the accident or those involved to get online and do a civilian report. Can you tell me, does this change that, this wording that's been in there making it shall? Would that be mandatory that the officers have to submit that in the event they investigate a traffic collision?
The language is designed to follow the statutory language on this. And there's a requirement in the statute for filing the report. So that's the goal in the language of this, to mimic what's required by statute.
Okay, so you answered my question. So the answer is yes, that would make that required. It's to enforce that. Is that correct?
I believe the statute requires it.
Okay.
It's my recollection of it.
Does that satisfy you, Senator Yates? Okay. Senator West, you have a question on the amendment, sir.
Yeah. it may be the amendment or the reg, either one, but I'm not sure. My executive summary that I have reads, require law enforcement officers who create a traffic collision report to utilize the electronic submission application. So the way I'm reading this is this doesn't require an officer to do a traffic report in every case. Like if they come up on a collision and I'm sure there are cases where there's really no need to do a full report. Some low-level fender benders. So I think it reads if they are going to do a report, they just need to make sure that's done electronically as well as written. Am I reading this correctly?
And gentlemen, I'm going to ask the state police people if they have some information while I take a quick look at this. That's my recollection of it.
Yes, sir. It's just if they make a report, we're trying to get them to utilize the e-crash system that we've had running for years now. We just want to make sure we're getting away from the paper.
But this is not a mandate that they do a traffic report on every single stop.
Correct.
Thing they come up. Gotcha. That's all I needed. Thank you.
Senator Yates has a follow-up question. Go ahead, Senator Yates.
Okay, thanks. Well, that absolutely conflicts with the last answer. It's as conflicting as you can, because I'm reading it, and so I understand that they're not required to make it everything, but it says, and it's mimicking the KRS 189-6353, but it's saying a law enforcement officer shall make a traffic collision report as required under the statute using the e-crash collision system in Kentucky, the portal, the e-crash system. So in the event that an officer shows up, they're obviously, we get reimbursement for our officers for everyone that they're there for the insurance companies. There's two people who've been involved in an accident. Is there a requirement that they document that through the e-crash system? Or is it appropriate the officer just leaves and doesn't make any documentation, therefore causing some issues with litigation later on? My understanding in other states is that if an officer stops, they talk to witnesses, they have got to document that, and as is other parts of your job that should be documented. Are you telling me today there is no requirement they document that in the event they stop, there is an accident, either injury or non-injury, you're saying that the officer can leave without documenting that?
Sir, my interpretation would be that if the officer stops there, documentation could be relaying that information back to the post or officer, whoever, whatever agency it is, telling them what happened, saying people involved didn't want to report. That could be an example that sometimes you have two people who it's small enough, or somebody does small enough damage that they don't even want to report at all. And so that'd be a situation where they're still documenting, but they're not actually doing a specific crash report that they're submitting to the e-crash system.
Okay. If I might chime in there too, on the KRS actually mentions $500 in damage. So sometimes if it is a very minor collision, an officer might show up and realize, this is just somebody scraped their bumper. It's not worth, as you mentioned, a full-on report. So they may not do it. But it does state that if an officer does show up, they shall investigate. That's where we would want the electronic report.
Well, it goes back to what this chapter requires rather than creating new requirements. The reg, it is intended to manage what the chapter requires in the KRS.
Thank you. And so my follow-up, the statute requires that in the event that there is, I think it's reasonably would be over, the damage would be exceed $500. So, but my understanding from all our other statutes, and we had a heck of a lot of litigation in Louisville over failure to document. So I just want to make sure that we're not misleading the public or anybody watching, that in the event that the officer stops on the scene of a collision, they've got to have some documentation there. And I think that Officer Atterbury explained that Atterburn, I'm sorry if I mispronounced your last name, just explained that very well. So there is some way, because what happens sometimes is that it may not look like there's a lot of damage, but let's say the sensors are messed up, it winds up being a few $1,000s, or someone's injured. Well, if later on they can say, I don't know what you're talking about, I don't have any problem. And if the officer didn't call that back, they didn't do some kind of documentation, then they're left without recourse. And we have done is we've contracted through insurance companies to get reimbursement based on collisions done to it, and we owe that to our individuals. So I know that we do require that. Unfortunately, I'm seeing it happen since COVID more and more where there's not documentation. So I just wanted to make sure that that was mandatory, that we are requiring it, and that nothing in the statute would change that.
Anything else, Senator Yates? Okay, we are dealing with the agency amendment. There has been a motion for approval of the agency amendment. Is there a second? There is a second. Without objection, it is so ordered. Now we are dealing with the regulation as the amendment. Are there any questions or comments on the regulation itself? There appears to be no other comments or questions. Thank you all for a good discussion. Please call the next regulation.
Education and Workforce Development Cabinet Board of Education, 702 KAR 1-116 with amendment, and 702 KAR 1-192 emergency.
702-116 establishes the criteria for fulfilling the training requirements of KRS 160-180 for School District Board of Education members. 702-1-192 emergency establishes paid quarantine leave for employees exposed to COVID-19 for the 2021-22 school year. The staff suggested amendments to 702-1-116 and 704-3-395 amends various sections to add a statutory citation and comply with the drafting requirements of KRS Chapter 13A.
In addition, also under the Office of Instruction, we have 704 KAR 3-395 with amendment.
Thank you. And 704 KAR 3395 establishes the provisions to fulfill the requirements of KRS 158-070 to provide an extended school services program.
Good afternoon. Would you please identify yourself today for the record?
Good afternoon. Todd Allen, General Counsel for the State Board of Education and Department of Education.
Mr. Allen, always good to see you again. Thank you for being with us today in our meeting. There are staff amendments. Is there approval, or is there a motion for the approval of the staff amendments?
Motion.
There is a motion and a second. Without objection, it is so ordered. Are there any questions from the members of the subcommittee for Mr. Allen? Senator West.
My question regards 702 KAR 1-192E. Is it your opinion that this E-reg is currently effective as we speak?
It is, Senator. Yes. There's also a companion ordinary administrative regulation that's going through the process. You may recall, I don't believe it was last month, but maybe the month before, ours reviewed that. It's my understanding it will become effective in May, the first part of May, and at that point in time, this emergency regulation will be withdrawn.
Okay. Do you have an opinion upon the effectiveness of this reg? Have you all taken into account SB 25 as it applies to this reg? Senate Bill 25.
Not sure that we've conducted that analysis, Senator, but I'm happy to do that and report back to you.
Okay. Thank you.
Any other questions? The committee will stand at ease just for a moment, please. The committee has, we have dealt with this in the past, and it appears through discussion of the subcommittee that after consideration 13A030, that this reg, specifically the reg 702 KAR 001 192 as filed with an emergency, it appears to be appears to us to be deficient, this reg does. And so I am going to make the motion that we find this regulation, this specific regulation, deficient today. There is a motion for the regulation. Is there a second? Second. There is a motion and a second. Is there any discussion? Senator Yates, did you have a question? Yeah, okay. Yes, go right ahead, please.
And I apologize. I was trying to follow. Would you mind just briefly summarizing why it is that we believe it is deficient in comparison to the Senate bill?
I think Senator West wants to follow up with that.
Yeah, I can answer that question. We passed this session Senate Bill 25, and basically on that list of regs, the ones that were on the list were allowed to flow forward. The ones that were not on list were null and void, basically. And Senate Bill 25 went into effect January 14th of this year. And so at that time, it's my opinion that this regulation became null and void. However, there isn't an ordinary reg that was filed by the cabinet, and I believe that is, per the cabinet's representative, it is on track to go into effect in May. But as it pertains specifically, this is really technical. I mean, but it is technical. Yeah. Hopefully that answers your question.
My only follow-up to that is,
yes, sir, go ahead.
In the event that we rule deficient null and void, and it looks like the new, I guess the gap bill will be in May, would there be any issues or problems between those months? Do we have to do anything with an emergency because of it going into May?
I do not know the answer to that question.
I do not either.
Yeah.
Would someone, Mr. Allen, would you like to answer that?
If that's the case, during that period of time, there will be no paid quarantine leave for school employees in the Commonwealth related to COVID-19.
Any other comments or questions? Senator Yates, please.
So, in our interpretation, our humble interpretation of the law the way it is, potentially being null and void in the event that we rule it, if we rule it deficient, we understand the outcome would be really getting rid of paid leave in the event during the quarantine area. Is that correct? And so it seemed like this humble body, would want to do everything we can to avoid that action. So would we be better off deferring this out and see if they can maybe get some kind of emergency in place so that we don't have a gap between today and May, because we do want to protect our workers. And so that would be my suggestion.
I am certainly fine with that. If Mr. Allen would be willing to defer this today, the committee will stand at ease for just a moment. Mr. Allen, sorry for your delay there.
No worries.
We do have before us a motion of deficiency, and there has been a second. The question on the motion to find this regulation deficient is that those in favor to find the regulation deficient will vote aye, and those opposed will vote no. It will take 5 votes in favor of the motion for the regulation to be ruled deficient. We will have a roll call vote at this time.
Senator Rocky Adams. Senator Alvarado.
Aye.
Senator Yates.
Explain my no vote, please.
Yes, sir.
While I see the direct conflict with Senate Bill 25 in reference to that, my hope was to defer that out to try to get either this body to be able to make an adjustment under the language of it, or to get the administration to be able to act. And for that very reason, I vote no.
Thank you, sir.
Representative Bridges.
Explain my vote.
Yes, sir.
I vote in favor of the motion, but I feel like we have law in place, and we're not allowed to go against that. And my question to education is, why were you not in here in January when that law went into effect? Why wasn't this caught? And we're waiting till the last minute, but I don't feel like we've got the authority to change the position we're in. So I'm a yes.
Thank you.
Representative Frazier Gordon.
Yes.
Representative Marzian. Senator West.
I'd like to explain my vote.
Go ahead, sir.
I vote aye. This is one of those, I think, weird COVID situations, and technically, in my opinion, this regulation as of January 15th no longer existed. So we're having to rule on this, and that's fine, because Senate Bill 25 was just passed on the 14th. But that's why we're having to find this deficient, is that per SB 25, it was null and void as of the 15th. I vote aye.
Representative Hale.
Not to be repetitive of what has been said, but my vote will be an aye based on findings of Senate Bill 25. So I vote aye. Would you please give us the total?
There are 5 aye votes and 1 no vote, so the motion to find the regulation deficient carries.
With 5 aye votes and 1 no vote, the motion, again, is to find this regulation deficient. If there are no further questions, please call the next regulation. Thank you, sir.
Thank you.
Labor Cabinet, Department of Workplace, 803 KAR 2, 321, and 426. Neither of these have additional amendments.
803-2-321 establishes definitions and adopts the requirements of 29 CFR 1910 Subpart G, Occupational Health and Environmental Control. 426 establishes definitions and adopts the requirements of 29 CFR 1926 Subpart X, Stairways and Ladders.
Please identify yourself for the record today, please.
Good afternoon. Robin Maples, Bosch Standard Specialist with Department of Workplace Standards.
Good afternoon, Chairman Hill and Co-Chairman West, members of the subcommittee and subcommittee staff. My name is Chuck Stribling. I am the Occupational Safety and Health Federal State Coordinator for the Department of Workplace Standards.
Good afternoon, Co-Chair West, Co-Chair Hale, Sam Flynn, General Counsel and Chief of Staff for the Labor Cabinet.
There are no amendments. Folks, thank you all for being with us today. There are no amendments. Are there questions from the members? Any members? Senator West.
Thank you guys for presenting. Could you fill us in on what the first reg, the CFR that it pertains to, what does that do?
So both of these regulations, Senator West, simply incorporate the federal requirements verbatim. We don't do anything different. It just strictly adopts the federal. You might recall we were in front of you last month with the emergencies on these, And it all stems back to the fact that I failed to get a certification letter submitted in a timely fashion. So we had to do them as an emergency to keep our federal coverage. And these ordinaries just take the place of the emergencies.
Quick follow-up, Mr. Chairman.
Yes, go right ahead, please.
So the second one, it says, pertains to stairways and ladders. Could you tell, what is the first one? What's the generally, what does it apply to?
Do you want me to take this, Chuck?
Sure.
It adopts Subpart G of 1910 in general industry, which applies to ventilation, occupational noise exposure, non-ionizing radiation. And again, it just strictly adopts the federal requirements.
And we have done this in the past?
Yes.
Okay. That was what I was getting at. Thank you.
You're welcome.
Any other questions? There appearing to be no other questions. Thank you for your time. Please call the next regulation.
Thank you.
Thank you.
Thank you.
Cabinet for Health and Family Services, Office of Health Data and Analytics, 900 KAR 10201. This does not have additional amendments.
900 KAR 10201 repeals 900 KAR 10200, Kentucky state-based exchange on the federal platform because the Cabinet is implementing a state-based exchange.
Would you please identify yourself today for the record?
Edith Sloan, Director of the Health Benefit Exchange.
Anyone else?
Kelly Rodman with the Cabinet for Health and Family Services. Sorry about that.
Who was the first individual that identified themselves? We didn't get that name.
Edith Sloan, SLONE.
All right, thank you. Thank you. There are no amendments to this specific regulation. Are there any questions? Yep. Senator West.
This is a general question. Anybody can answer. How long have we been trying to implement the Kentucky-based exchange? And is it cheaper for us to do a Kentucky-based exchange or to remain on the federal platform?
Edith, can you answer some of those questions?
I sure can. I was waiting to see if you were going to, because you're a better
Go right
speaker
ahead.
than I am. Yes, it is less expensive. I think the last one that we got the figures on was $15 million, and we can actually do it on a state-based exchange at $2 million. I'm sorry, let me clarify, because I don't want to see if it'll cost us $5 million this year to make that change, and then $2 million a year after.
And if we let if we stay on the federal platform, did you say it would cost us $15 million a year?
It changes. They fluctuate the percentage, but the last one that we got figures on was almost $15 million. Yes.
Okay. Thank you.
Mm-hmm.
Any other questions, please? There appearing to be no questions, please call the next regulation.
Department for Medicaid Services, 907 KAR 3170. This has an agency and a staff suggested amendment.
907-3170 is being amended to establish a recipient right to receive care in person or via telehealth, establish the general rule that telehealth services are reimbursable if they are appropriate and safe and not prohibited by the provider's licensing board, allow an initial visit to be conducted by telehealth, establish telephonic service requirements, specify instances where telehealth is prohibited, address telehealth provided by out-of-state providers, include remote patient monitoring, and allow the department to post an informational listing of service codes that are not allowed or subject to additional restrictions. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A. The agency amendment deletes Section 5.3 regarding out-of-state providers.
Would you please identify yourself today for the record?
Good afternoon. I'm Jonathan Scott. I'm Regulatory and Legislative Advisor for the Department for Medicaid Services.
Good afternoon, Mr. Scott. Where have you been?
Around.
We've missed you for a couple of months. You are a regular at our meetings. Welcome back today. There is a staff amendment. Is there a motion for approval of the staff amendment? There is a motion and a second. Without objection, it is so ordered. And there is also an agency amendment. Are there any questions or I'm sorry, are there any discussion on the agency amendment? There appears to be no discussion. Is there a motion? There is a motion. Is there a second? There is a second. Without objection, it is so ordered. Do we have any questions on the regulation as amended by the agency amendment? Senator Alvarado, no questions? This is your baby, no questions?
No, I've reviewed these, Mr. Chairman. No, it looks okay to me.
All right, great. Thank you. Thank you, Mr. Scott. We appreciate your time. Don't to make yourself a stranger. Come back and be with us next month. There being no further questions, please call the next regulation.
Department for Aging and Independent Living, 910 KAR 1190. This does not have additional amendments.
910 KR 1190 amends to update requirements based on the 2020 USDA Dietary Guidelines for Americans and for Disaster and Emergency Preparedness and allows seniors the opportunity to receive culturally or therapeutic appropriate meals.
Would you please identify yourself today for the record at this time?
Yes, my name is Commissioner Victoria Elridge with the Department for Aging and Independent Living.
Anyone else? All right,
Amanda Stess.
I'm sorry, go ahead.
Amanda Stess, registered dietitian with the Department of Aging and Independent Living.
There are no amendments. Are there any questions from any of the members of the subcommittee today? There appears to be no questions. Thank you, ladies, for being with us today. Please call the next regulation at this time.
Department for Community-Based Services, Energy Assistance Program Weatherization, 921 KAR 4122 without additional amendments, and under Child Welfare, 922 KAR 1360 Emergency. This also does not have additional amendments.
921 KR 4122 establishes the criteria and process for low-income households to receive assistance in paying water or wastewater utility arrears accumulated between May 27th of 2021 and September 30th of 2023, utilizing funds from the Federal Consolidated Appropriations Act and the American Rescue Plan Act of 2021.
Would you please identify yourself today for the record at this time?
Good afternoon. My name is Laura Beacon, and I'm the Regulation Coordinator for the Department for Community-Based Services.
Thank you very much, Ms. Beacon, for being with us today. There are no amendments. Are there any questions from any of the members for Ms. Beacon today? Appearing to be no questions, thank you very much for your time. Please call the next regulation at this time.
That concludes our agenda for today. Except for other business that we have, which is under Cabinet for Health and Family Services, Office of Inspector General, 900 KAR 14010 Emergency. This has an agency amendment.
900 KR 14010 Emergency establishes guidelines for the implementation of essential personal care visitor programs in assisted living communities, long-term care facilities, and state-owned or operated psychiatric hospitals during a period when general visitation is limited or prohibited. The agency amendment amends Section 2 to delete provisions relating to temporary suspension of essential personal care visitation, and Section 3 to state that facility training on infection prevention and control is only required if it is mandated by the facility's written policies and procedures, and delete the requirement to include specific types of training.
Would you please identify yourself today for the record at this time?
Thank you, Co-Chair. My name is Adam Mather. I'm the Inspector General for the Cabinet for Health and Family Services.
And Kara Daniel, Deputy Inspector General.
Thank you both today for being with us. There is an agency amendment that has been asked to be put on this reg, correct? Am I correct on that? Okay, yes. Would you explain this please, this emergency regulation to us today?
Sure, this is to comply with Senate Bill 100 in reference to essential caregivers. And upon further consultation with the members of the General Assembly, thus the agency amendment to better reflect the statute with Senate Bill 100.
Are there any questions after the explanation of the agency amendment? Senator West.
Could you go into a little bit more detail on the agency amendment, what it specifically does, please?
Yeah, certainly, Senator West. So it will delete the the ability for the facility to restrict visitation for essential caregivers during an outbreak or communicable disease issue. And then the other section is around not requiring specific training to happen for essential caregivers. It would be a reflection of the facility's policy as to what they were trained on.
Thank you. Motion on the amendment.
There is a motion on the amendment. Is there a second, please? There is a second to this amendment without objection. It is so ordered. Thank you both for being with us today. This does conclude the agenda for today's meeting. The compiler will announce to us at this time the next regulation meeting.
We've got the next meeting set for Monday, April 11th at 1:30. That is during the veto period. Oh, sorry, 1 o'clock. Thank you.
Okay, everyone, please take note of that. That will actually be during the veto period before the last two signing night, the last 2 days we will be here. It has to be done on that. It has to be done sometime during that period before the 15th of April. So there was really no great day to pick. So we tried to find the best day we could. So that will be on Monday. The date again on that is
the 11th at 1.
Monday, April the 11th at 1 o'clock for the next meeting. Just a second. The committee will stand at ease just a moment before we adjourn.
Yes.
I'd like to thank everybody for coming in early today on a Monday. Thank you for being here. A lengthy meeting today, but I appreciate everybody's time.